Hello, everyone, and welcome to part 9 of Polity Premier League. Let's begin. First question. Which of the following constitutional or legal principles ensures judicial independence? So, judicial independence is ensured through separation of power. Yes. Through the security of tenure of judges, wherein the judges can be removed only through a special majority, right? And that too on the ground of proved misbehavior or incapacity. Then the Judges Inquiry Act, yes, this is the law which looks into the procedure that needs to be followed while removing the judges. This is also there to ensure judicial independence. The expenses of Supreme Court being charged on CFI. What is charged expenditure? It means no voting. Okay. Direct approval, you can discuss those things, but no voting is to be done. So, yes. And then the fifth one, the CGI as the master of roster. So, what is this master of roster for CGI? See, as far as this concept is concerned, it simply means that CGI is the person who is authorized to allocate cases amongst the various benches, meaning which case goes to which kind of bench, and then how will the bench be formed, which judge will be part of which kind of bench. All these tasks, these functions, which are internal administrative functions, are performed by CGI, and hence he is called the master of the roster, which has got nothing to do with judicial independence strictly. So, of course, 1, 2, 3, and 4 are right. Fifth is not right. Answer is C. Question number 2. Which of the following statements regarding removal of Supreme Court judges are correct? A judge can be removed only by an order of the President based on a motion passed by both houses of the Parliament by a special majority. Yes, this is absolutely correct. The special majority which is required to approve or rather to pass a motion for the removal of the judges of the courts, and then such a motion, once passed, is sent to the President, who will have to sign it within the same session. Second one, when a removal motion signed by the members of parliament is given to the speaker or chairman, he or she can refuse it. Yes, of course, this is one more step, one more layer to ensure safeguards for our judiciary, as and when the motion is raised by 50 MPs in Rajya Sabha or 100 in Lok Sabha, the presiding officer has full right to cancel or refuse it. Number 3, the committee that investigates into the charges against the judge consists of the members of parliament from both the houses. This is wrong. This committee, which is referred to as what? Referred to as the Judicial Inquiry Committee. This committee comprises of judges, the Chief Justice of India or any senior Supreme Court judge, also comprises of Chief Justice of the High Court and a distinguished or eminent jurist. So this is a judicial committee. Hence 3 is wrong. Right answer is C, 1 and 2. Next question. With reference to recusal of judges, consider the following statements. As per the Judges Inquiry Act 1968, if a judge does not recuse himself or herself from a case involving conflict of interest, it can become one of the reasons for the removal of the judge in the parliament. And number 2, having a prior or personal association with a party involved in the case can be a reason for the recusal. This is actually correct. So this is what recusal means. Recusal means when you take back your name, you withdraw yourself from a case because you might have had some personal, some prior association with either of the parties involved. Now, this is done to ensure principles of natural justice, the idea of fairness, the idea of due process, and not just this, nema causa in judex sua. No one shall be a judge in their own case. Now, however, it does not mean that recusal is a reason for the removal of a judge. It could be if the parliament decides, but the broad categorization of reason is misbehavior or maybe incapacity. Okay, so 1 is wrong, 2 is right. Right answer is B, 2 only. Next question. In which of the following cases the Supreme Court does not have the exclusive original jurisdiction? Exclusive original meaning you can go directly to the Supreme Court and you can go only to the Supreme Court. No other court has this authority, has this jurisdiction. So dispute between the government of India and one or more states, yes, this is an exclusive jurisdiction, hence not a part of our answer. All federal disputes are exclusive original jurisdiction of the Supreme Court. Dispute between two or more states, yes, this is also a federal dispute. Interstate water disputes. Now, interstate water disputes are those kind of disputes which are governed through tribunals. The Interstate River Water Disputes Act of 1956. In fact, the law itself says that the awards of tribunals are barred from being challenged in the Supreme Court as the Parliament may decide. So, this is not an exclusive and original jurisdiction. So, this would mean that this is a part of the answer, rather. Okay, then the fourth one. Enforcement of fundamental rights, we know this very well. This is a writ jurisdiction and it is shared along with who? The High Courts under Article 226. So we already have the answer. If 1 and 2 are wrong, then this is wrong. 3 and 4 are correct. So B is the right answer. And the fifth one, this means it has to be correct. Adjustment of certain expenses and pensions between the center and the states. This means the right answer is B, 3, 4, and 5 only. Next question. Which of the following statements are correct? Constitution of India has given power to the Supreme Court to hear a petition as an appeal even if a High Court refuses to grant a certificate for the appeal. Yes, this is what is called a special leave petition. Article is 136. So, Supreme Court can entertain any kind of petition as an appeal against any order, decree, conclusion of any court or tribunal in the territory of India. So one is correct. Special leave petition is a discretionary power of the Supreme Court and cannot be claimed as a matter of right. Yes, it is a discretionary power of the Supreme Court and you cannot force the court into accepting your petition. You can only request. And if the Supreme Court finds merit in your case, like if you bring an elite lawyer or you are rich, sorry, if the case is very important, it is maybe causing some grave injustice, then the court will accept the petition. Simple. So D, both 1 and 2 being the right answer. Next question. With reference to the powers of the Supreme Court of India, consider the following statements. Its advisory opinion given under Article 143 is binding on all authorities in India. Yes, Article 143 does provide for the advisory jurisdiction. And yes, the advisory opinion is binding on all the courts within the territory of India. However, not on all the authorities. This advice is not binding on the government. Okay, so one is wrong. The Supreme Court can directly entertain a petition for violation of fundamental rights under both Article 32. Yes, under Article 32, of course. And under Article 226, sadly, no, this is the power given to the High Courts. So 2 is wrong. Which statement is correct? So in this situation, neither 1 nor 2 being correct. Next one. Which of the following powers of High Courts are explicitly, clearly mentioned in the Constitution? Power of judicial review. See, judicial review as a concept is not mentioned in the Constitution. Power to issue writs for enforcement of fundamental rights. Yes, Article 226 clearly provides this kind of authority to the High Courts. The power of superintendence over all courts and tribunals within its jurisdiction. Yes, this is also correct, clearly mentioned in the Constitution. And the power to review its own judgments. Sadly, this is not correct. I know you might think that the High Courts are court of records under Article 215, which means that two special features of court of records are also available in the High Courts. Like the court of records have the power to issue for contempt of court, and also the Court of Records can review their own judgments. However, these two things are not explicitly mentioned in the Constitution for the High Courts. So the right answer is 2 and 3. These two are clearly mentioned in the Constitution. B. Next question. Consider the following statements regarding subordinate judiciary in India. The jurisdiction and the powers of district courts are determined by the state legislature. Absolutely correct. Subordinate courts are constitutionally placed under the administrative control of the concerned High Court. Yes, Article 235. This is also correct. The Constitution empowers subordinate judges to issue writs under Article 226. So, just to clarify, the Constitution does not empower the subordinate judges to issue writs. This power is meant only for high courts. So 3 is wrong, 1 and 2 are right. Right answer is A. Next question. Which of the following statements regarding the Lok Adalats is or are correct? Lok Adalats have the same status as a civil court under the Code of Civil Procedure. Absolutely correct. Number 2. A Lok Adalat is chaired by a sitting or retired Supreme Court judge, and its decision is binding only if both parties give written consent. Just to clarify, Lok Adalat is chaired by a sitting or retired district judge or an additional district judge or any person above the rank of these categories. So 2 is wrong, 1 is right. Right answer is A, 1 only. Next question. Which of the following disputes cannot be taken up by a Lok Adalat? Disputes related to compoundable criminal offenses. So, what exactly is a compoundable criminal offense? These are petty offenses where out of court settlements are possible, are allowed. So, of course, this case can be taken up. Motor accident compensation claims, yes, they can be taken up. Matrimonial disputes, they can also be taken up under the Parivarik Mahila Lok Adalats. Okay, so this is also there. Hence, D has to be the right answer. Cases pending under non-compoundable criminal offenses, meaning those offenses which are serious in nature, where out-of-court settlement is not possible. Now, the next one, which of the following best describes the jurisdiction of Gram Nyayalayas under the GN Act of 2008? So, only civil disputes related to land, tenancy, and family matters, only petty criminal cases. Number 3, both civil and specified criminal cases. Yes, Gram Nyayalayas can take care of both civil as well as specified criminal cases, where the punishment is up to 2 years of jail. The maximum fine is up to 20,000 rupees. So, C is correct. Only revenue and tenancy cases, of course, not. Next one more question on Gram Nyayalay. Which of the following statements about Gram Nyayalays is or are incorrect? GNs are presided over by the Nyayadhikari who enjoys the same powers as a JM first class. Yes, correct. Appeals from GN in civil matters lie directly with the High Court. So, of course, Gram Nyayalays pertain to petty offences, right? Why would the appeal lie directly with High Court? It lies with the district court, and the condition to be met is if the fine is at least 1,000 rupees, only then. So 2 is wrong. The GN has no authority to exercise mobile court functions. In fact, the GN was built to ensure mobile court functions. So this is also wrong. Right answer, incorrect. 2 and 3, C. Next one. Judicial activism is best understood as a manifestation of which of the following underlying constitutional principles? Separation of powers, yes, of course. Rule of law, yes, of course. Rule of law has to be upheld at every and any cost. So this would mean that what? This would simply mean that the law is the king of all the kings. Lex Rex, not Rex Lex. Parliamentary sovereignty, of course not. In countries like UK where the parliament is sovereign, you can understand this very simple idea that any judicial review is not possible for legislative action. It is only possible for or is limited to executive action. 1 and 2, C being the right answer. Next one, with reference to the tribunals in India, which of the following statements is correct? Only the Supreme Court has a power to review the decisions of all the tribunals. So it is not the Supreme Court but the High Courts which have been given the power to review the decisions of tribunals. This was done through a very famous judgment. I would like all my innocent aspirants to write in the comment section what was the judgment, the name of the case. By the way, NGT, the National Green Tribunal, is a very unique one because its awards are to be challenged in the Supreme Court only. All tribunals fall under the supervisory jurisdiction of the respective high courts. This is actually correct. Article 323 capital A allows both civil and criminal matters to be adjudicated by tribunals is wrong. This is meant for what kind of matters? Administrative matters. When I say administrative matters, I mean to say service matters related to the central and state government employees. So in case in future, if you clear the exam, then maybe your recruitment issues, your transfer issues, your salary, pension, all such issues that you might face, let's hope you don't, then you can go to the CAT or the SAT to get those issues resolved. D. Tribunals can be established only by constitutional amendments is wrong. Under 323 capital A, tribunals can be established under what? Under an act of parliament. Parliament by law. And when it comes to 323 capital B, tribunals can be established by either parliament or by the state legislature by law. So this is also wrong. Right answer is B. And this brings us to the last question of the day, with reference to the Central Administrative Tribunal established under 323 capital A of the Constitution. Consider the following statements. CAT has jurisdiction over service matters of both civil and military personnel is wrong. For military personnel, we have the separate armed forces tribunals. So one is wrong. It is not bound by the procedure laid down in the Code of Civil Procedure. Yes, the CAT and such tribunals are free from these procedural shackles. They provide fast, quick justice. So, 2 is correct. Appeals against CAT's decisions lie only with the Supreme Court is wrong. Appeals against CAT's decisions lie with the High Courts. So this is wrong. The 4th one. The removal of members of tribunal is similar to that of High Court judge is also wrong. The members of tribunals are not removed through voting in the parliament. They are removed by a simple process of inquiry. Okay, so there is no need for voting in the parliament, which is a process followed for the removal of High Court and Supreme Court judges. So which statement is incorrect? So the right answer would be 1, 3 and 4, which is B. This brings us to an end of our discussion for today. Let's meet in the next video. Till then, that is all for me. Jai Hind.